Ivars, am I saying that right? Ivars. And I have council, case number is 233281 for the record. If I can have council identify the folks.
Morning, Sharon Degnan on behalf of
And Brian. All right. So you're recognized. Miss, is it, did you say Degnan?
May it please the court? Yes, 5 minutes rebuttal, please, Your Honor.
Okay. You recognize.
We're here today asking the court to reverse a $1.3 million verdict in an uninsured motorist auto negligence case and order a new trial at which both parties can present their witnesses to the jury. It's Geico's position that the trial court's ruling striking Geico's medical experts on the eve of trial eviscerated Geico's defense by preventing it from offering any expert testimony to rebut causation, permanency, and challenge damages. We believe the trial court abused its discretion in striking Geico's experts for an inadvertent late disclosure made 3 months before trial without conducting the required analysis under Binger versus King Pest Control. So I guess we'll be called the Binger .2 case for the day today. As the court knows, the Binger analysis requires that the trial courts be guided primarily by the question of whether using a late disclosed witness will prejudice the opposing party, meaning creating surprise and fact. Now, in preparing for the oral argument, I think, looking at all of the Binger case law that exists in Florida, I think it's really important to recognize that there's sort of different baskets of Binger case law that exists in the state that are based on different.
Counsel, if I could just kind of jump right into it.
Sure.
So understanding the Binger factors, one of the factors is bad faith, obviously. Your allegations here today, or your position is that the court didn't analyze, didn't speak to the Binger factors. But in the court's order, it does say that based on the totality of circumstances, this appears to be a crisis of the defendant's own making and delay, including but not limited to failing to abide by court orders, file motions for leave or extension of time, or bring motions and ongoing scheduling issues to the court's attention in a timely manner. And I apologize, it's going to be a little bit of a long question, but necessarily so. And the court also earlier mentioned in the same order that you did not attach any affidavits or provide any evidence to show that it was in fact just a calendaring error that you made. So how do we, and then in your motion for reconsideration, you also, even though the court told you that in their order, you filed a motion for reconsideration and did not attach any affidavits and didn't give any evidence to the trial court to say this was just an innocent calendaring error. So when you say that the court hasn't found any of the Binger factors, don't we have bad faith here? Couldn't we hang our hat on bad faith?
Well, I don't think so, Judge, because I think when you look at the Binger case law, I think the first thing it says is that the first thing you have to find is that there's prejudice.
Okay,
You
so
know, and
counsel,
I'm sorry. No,
your,
you asked the questions.
no, your position would be that it goes prejudice, that's the most important, and it can't be overcome by any of the other factors the court says we may look at.
Well, I think the first thing you have to look at is, was there prejudice? Was there surprise and fact?
Didn't she find prejudice? She found prejudice in her order, doesn't she do that? Because she says that she rejects your prejudice analysis to say, well, the time for trial is the right time to look for, because she says there is prejudice because discovery has closed, right? She finds that is her
Right.
prejudice finding, correct?
Well, I think her finding was that she was very frustrated with the parties and found on the eve of trial that they were having difficulty communicating and therefore said, so I'm going to strike Geico's experts. But I think you have to take a step back. And when you look at what the prejudice analysis, I think you have to look at it from the perspective of this was a disclosure that was made several weeks late. It was, admittedly. It was still 3 months before trial. And there was no, I mean, the finding of bad faith that would be made when you read in the context of Binger case law is this concept of ambush or gotcha, trying to hide something from someone so that they get an unfair advantage in the litigation.
Wasn't the motion to strike filed right away?
The motion, yes, the timing of everything created.
Couldn't your client have scheduled that hearing right away as well?
The hearing could have been set, but again, I think the issue, Your Honor, is if you look at the Binger case law, I think the concept of prejudice, meaning surprise and fact, did the other side know the opinions is the primary thing.
But that's two
So
separate
to-
arguments, right? There's, she didn't make a prejudice finding, and there's, she abused her discretion in her prejudice finding, right? Those are two separate
Well,
arguments.
I don't think she made a prejudice finding.
Okay, but if we disagree with you there, if we think that her order on record site 961 makes a prejudice finding when she talks about the discovery deadline having come to pass, right? If we find that to be a prejudice finding, then your argument has to pivot on the fact that that prejudice finding was wrong.
I would say that it's wrong because the fact of the matter is the expert had been disclosed, all of the opinions had been disclosed months before the discovery cutoff. I mean, that's the issue. If you apply Binger analysis here, the question is, what was the other side surprised in fact by the opinions, or were they made available? And the answer to the question, they absolutely were, as soon as the experts were disclosed. And what happened here again, I mean, it's clear that what happened is that Orange County has a different procedure than other courts. And I've seen this happen in other cases where you have to do an expert disclosure and then you do a witness and exhibit list. And what happened here is that first disclosure wasn't calendared. So the first disclosure came February 14th, 2023. Discovery cutoff was in April and the trial was in May. So in February, that's when the disclosure was made. Immediately thereafter, the next day, the motion to strike was filed. And I agree, it could have been set for hearing, but the fact it wasn't doesn't change the fact that immediately thereafter, Dr. Cousins' report was given the next day, February 16th, was given to the plaintiff.
Can bad faith ever overcome lack of prejudice?
I don't think so. And I think when just using the word bad faith or using the word prejudice, it has a specific context in this Binger analysis. And when I think the cases where there's been a finding of bad faith and what the Supreme Court meant in Binger when it used the term bad faith or intentional is trying to trick someone, waiting until the last minute, purposely say, not disclosing an opinion and then saying, aha, I want to use it. That's what's meant by bad faith. I mean, at the end of the day, I think Binger and its progeny, as it's been used, and when you look at these cases like Thorne or all these cases where months before trial, even though it doesn't technically comply with the order, an expert is disclosed and they know what the name of the expert is and they know the opinion, then it's an abuse of discretion not to allow the witness to testify. To strike every witness that we had, basically, our ability to defend the case based on something when they knew the substance of their opinion.
Counsel, you were going to talk about there being different baskets of Binger cases. I'm interested in that analysis.
Yeah, I think it's very important. And I think sort of you look at the case you heard this morning, or you look at one of the cases cited in the answer brief is a case called Krisiak versus Dawson, where opinions were given by an expert in a deposition. And in Krisiak, what happened is the expert said, I didn't analyze post-traumatic stress disorder and whether or not the plaintiff suffered from that in their deposition. Then the day before trial said, oh, guess what? We did. We're going to now testify that the plaintiff has post-traumatic stress disorder. And the court said no, and analyzed Binger analysis and said, no, that's an ambush. That's a gotcha. That's a surprise in fact. And that analysis under Binger, the fourth district said, you're right to say that that expert couldn't testify. That's very different than what we have here, where the cases pretty unanimously have said that where, even though there may be a late disclosure, if the disclosure can be cured, right? A party that does that can do what it has to do to cure any prejudice by disclosing the opinions and making known what's going to be testified in advance of trial, so that nothing has to be changed, the trial date doesn't have to be changed, then the expert should be allowed to testify. And we believe that's what this case is about.
But let's go, you agree this is under abuse of discretion, correct?
Correct.
Going back to my point that I'm not gonna second guess the trial judge of all the things going on. We read the emails going back and forth. Professionalism could have been different. But your client was aware early on, once they noticed him, that their intention was to strike. Months go by. And now you're asking us to say, when this trial judge finally gets it in front of her and has to make a decision, we should find she abused her discretion when months prior, something could have been done. You could have had the hearing, you could have presented it then, and maybe the result would have been different, but you're asking us to then come in later and overturn it.
But Your Honor, there was a hearing in April that took place,
In
right, on April, and the judge actually recognized that under Binger, she said, how can I possibly strike this witness under the analysis? How can I find, when you have time to get the opinion? And she said, I'm gonna enter an order, and she didn't. And I'm not, look, I can't say that this couldn't have been done differently by everyone, quite frankly, and
Counsel, I do have a question, because as I look, there's a little bit of a mystery here in this record to me, because as I look at the motion hearing on the motion to strike, I see it pretty bare bones, as to the arguments that are raised, and, the motions themselves and the response are fairly bare bone. And then when we get to the order is 4 pages long, 17 paragraphs, all sorts of stuff that I don't see anywhere mentioned in either motion or at the hearing. Do you know who prepared this order, first off? The one that was submitted to the court on the order of the motion to strike, the order in question, the one entered on May 18, 2023. You know who
I
prepared it?
don't, to be honest, I don't think the record shows anything regarding that.
Do you have any idea where the court got all this information? How she was able to put all this in here that wasn't presented to the court?
Well, I can
and
tell
wasn't
you,
presented at the hearing?
yes, I can tell you that in putting it together myself, I think this is what happened, is that as the case was about to get set for trial, you can tell from the record that one of the things that happened was that as soon as the motion to strike was filed, defense counsel kept trying to get plaintiff's counsel to agree to a deposition date. And he kept saying, give me a deposit. And he said, I absolutely will not. Even before the motion to strike was heard, he kept saying, your expert's stricken. I'm not agreeing. I'm not agreeing. It was set, the hearing was set April, I think it was April 14th or April 17th. I apologize. I forget which one of 2023. And so they were trying to set the date, and plaintiff's defense counsel said, I am setting this unilaterally. And the reasoning for doing that was to obtain the testimony. And he kept saying, if you will agree to a date with me, I will set it. If you're not available this date, tell me what date you're available. So that the depositions went forward in April. Okay. And then what happened is, I think what the judge got upset, because during the hearing, it became clear that those depositions were set unilaterally, and she got upset with that. And she got upset with none of the hearings being set timely. Now, during the April hearing, plaintiff's counsel said he didn't have time to set it before. He had gone from trial to trial to trial, and that was the earliest he could do it. But at the end of the day, I think it was the judge's frustration with both parties that got her, she was unhappy with both parties. And I would say unfairly resulted in her striking on the eve of trial, because there had been a little earlier a hearing where she said, how can I strike these experts if there's time? And if, there's no, I don't think she used the word prejudice, but she said, how can I do it if there's time for you to?
And counsel, were these all of your experts that were stricken?
Correct. It was all of them, but the two main ones that they clearly had Dr. Cousins' report. They had all of Dr. Bain's file. They served expert discovery that we timely responded to, had all of this months before trial, that they had all that. So again, to answer your question, Judge Smith, I think it was the trial court's frustration, but that's not the right analysis. And we'd submit the fair thing to do wasn't to say, oh, Geico, your experts get stricken. And I don't think she did the correct analysis under Binger. Because I think she recognized months earlier there was no prejudice, and I think she would have, there was no prejudice. They knew the opinions. And I think even in terms of bad faith, I would submit again, sort of what we were talking about. I do think there's a context in which bad faith exists. And where a party provides the opinions right after, immediately provides it, does everything they can to set a deposition, says, come to it, here's the opinions, here's the report, months before trial, that can't constitute bad faith.
You're in your rebuttal time, but you're welcome to continue. if you'd like.
If anyone has anything else, otherwise I'll wait and hear what my opponent has to say.
Okay.
Thank you.
Lisa Court, my name is Brian Lee. I'm representing Patrick Wyvars. I think it's Wyvars. It might be Uvars, but I'm gonna go with Wyvars because that's what I've been saying in my brain the whole time. So when we look at this particular order, and the court's already talked about the standing review, I'm not gonna repeat that. I think it's important for us to talk about Binger first, because Binger was a case about a pretrial order. That's how it originally came to the Supreme Court, and there were a lot of different things.
Counsel, if I apologize, I know we were all gonna have probably a lot of questions for you.
Absolutely. No.
Jumping right into
Sure.
it. Going to my first question that I gave to your opposing counsel.
Right.
Are you aware of any case where bad faith alone was enough to justify a Binger strike without a finding of prejudice?
I know that they sometimes mix it. And the reason I say that is because whenever there's bad faith, they typically find that there's prejudice, right? So there's two different things. I think actually, if you look at Binger to me becomes the closest that there is to actually say that bad faith is prejudice. And that's because when I'm looking at the ruling of Binger, which was a situation where there was rebuttal witness, and that at the end of the whole analysis that the Supreme Court does, it says, this intentional non-disclosure combined with the surprise occasioned by the use of it convinces us that the defendant was prejudiced in the presentation of the case. So it doesn't say that, there was prejudice and then there's this bad faith, and it says the intentional disclosure itself led to prejudice. So I think that there is a situation, of course you can have prejudice without bad faith, but I think under Binger and how it follows, you can't have bad faith without prejudice, right? Once a trial court makes findings that this was not done just as an aside or as a non-intentional act, then I think prejudice is established. And we have in this case, I've gone through the timeline, but I think it bears repeating, because we didn't just have a situation where trial order says one thing, it's a late disclosure, and there's actually the disclosure that the trial order contemplates. That's not what happened in this case. We had a trial order that had two kinds of disclosures for both parties. Had a disclosure of expert witnesses and all the things that went along with it, as well as a disclosure of trial witnesses and exhibits. The trial witnesses and exhibits obviously were closer to the pretrial conference. That's what you would normally do. That's part of the local rules. The disclosure of expert witnesses is something different. And part of that, as I noted in my brief, is that when you disclose all the opinions that are the substance of the opinions, you're also supposed to disclose deposition dates for those witnesses to be deposed as part of discovery. So the order contemplates that. What we have in this case is we have plaintiff doing that, my client disclosing experts as they should, and then 15 days later, defense was supposed to. And then 45 days after that, actually more than that, defense discloses these experts. They don't disclose them in a disclosure of expert witnesses like the order contemplates. They put it in their trial witness and exhibit list, which is a totally different disclosure. What they also don't do is they don't give deposition dates. That's important because they disclose that as part of a separate disclosure, which isn't the original disclosure. Plus, then they start trying to get deposition dates, not for the plaintiff's counsel to say, hey, look, you need to take the deposition of this expert. We're going to give you dates to do that as the order contemplates. No, they wanted to get deposition dates for video depositions they were going to take of their experts to show at trial. And we know that because they went ahead and unilaterally did it. They took their deposit of these two experts, and then later on, right after they got the transcripts, designated those.
But
to the
counsel, do
court.
you dispute your opposing counsel's view of the record that that they were trying to coordinate deposition dates with your side, and your side said, no, we're not going to do it because we've got a motion to strike floating out there?
I think there certainly was, and you can see from the emails, that they were trying to get deposition dates. I don't think that I wouldn't categorize that as, they were working, because Mr. Rudd made it very clear that he was in trial those weeks. And this wasn't, these were deposition dates. There wasn't some issue of like, well, we're doing these deposition dates because we want to make sure you know all the opinions, and then we're going to go ahead and do our own. This was, we want to get these deposition dates set. And when they didn't, they went ahead and unilaterally did them. And it wasn't a discovery deposition that they took. This was a trial deposition they were taking of, that's why they wanted the dates.
But I mean, had your client, had your side said, okay, we'll
take it.
agree to it. I mean, you could have turned it into a discovery deposition, correct? You could have asked the questions that you wanted to ask based on the report that they gave you.
Sure. I mean, if Mr. Rudd would have kind of brushed aside his motion to strike and said, yeah, I'll agree to it, and then go there, and he could have asked questions, he could have done that. Certainly. But, I guess the impetus for that is that, and I go back to the trial order. The trial order was set up in a way that when you disclose experts, either party, the court's order talks about discovery of those opinions. And it starts with giving the dates for discovery, but it also then ends with, hey, you got to do that within 10 days. And it says the other side has to do it within 10 days or get the deposition dates done. And if they don't, you as the disclosing party can get in front of me, meaning the court, and we can discuss that at short matters and things of that sort. So there's a whole mechanism that the trial court entered to be able to do that. What defense counsel and defense did was circumvent that entire strategy. So they didn't do any of that. And in doing so, how am I going to say this? If this was a just mistake and a clerical error, and it was supposed to be put for a certain date and it was for another month, it would have been extremely easy for them to have someone come in, an affidavit from somebody that says, yeah, I put that for this date and that. I think it is very telling that when the trial court held the hearing on this motion, after Mr. Rudd made, frankly, a short argument, but he basically said, look, I put it in my motion. When Judge Rodriguez went over to defense counsel didn't have anything to say, really. Defense counsel said, well, you've already read my memorandum. We'll just rest on that. Nothing about anything else, no evidence. And then, as the court has already alluded to, once the order came out and said, look, you didn't provide me anything. When they file their motion for reconsideration, they go through the motions to do that. Nothing in there either. And so I take issue with the, I guess, foundational argument that they're making that, well, this was just an inadvertent error. I don't take that at face value for judges. And I think the trial court looked at the evidence and didn't either, which is why she did what she did. Now, I did want to answer, I'm sorry, honey, you had a
No, I'm
question?
going to change gears. So if you wanna
Okay, I
finish your
do
thought.
want to answer one question I think that you asked Judge Smith was, do we know how the court got to the order? I do know, after at the hearing, the short hearing, I think at the end of it, the court said that the court was going to do an order on it. And what occurred then, we don't have the transcript. I'm not even sure there was one, but I did cite to clerk minutes that was in the record. And if you recall, I said earlier, there were deposition designations of both these experts done. Mr. Rudd filed a motion to strike those deposition designations. That was heard at a hearing. And it happened on, I want to say the 17th, if I'm not mistaken, May 17th. The clerk minutes show that the judge granted his motion to strike those depositions from being heard at trial. The very next day is when the order came out. So, I don't know this for certain, but you know that these things were to come out as far as the depositions and unilaterally setting and all those types of things came out in that hearing. And so I see this order that the court did as a sort of a conglomeration of everything that had come up to that point. And that was what her order ultimately was.
Okay, I have a question for to pass off. Because I want us to get out of here without discussing the form of the judgment.
Yes, sir.
And counsel, if you can be ready to address that in your short about remaining as well. So
That was my gear change.
Okay, all right.
Council, I see that as a really
Oh, you
important.
want me to, okay, I
Yeah.
didn't know if you had a question and that you wanted me to
Uh,
specifically answer about it.
Well, yeah, we have lots of questions, I'm sure. I
Sure.
certainly do. It seems to be a big issue in this case that divides the fourth and the second DCA
Right.
on what the form of the judgment should be. I'll start with Florida statute 627.427 regarding payment of judgments by insurer or penalty for failure. That says every judgment or decree for the recovery of money entered in any of the courts of this state against any authorized insurer shall be satisfied within 60 days from thereafter from the entry, basically, is what it says.
Right.
If we accept your argument that you're allowed to enter the judgment in full when the debt hasn't been made in full against that party, and then just limit it to execution only for the amount for which they would be bound by contract to pay, doesn't that put them in a situation where they cannot comply with that statute?
And I'm trying to actually look for the actual judgment itself. I was kind of flurrying as you did that, but typically what happens is, and I think in this case, there was a separate part of the policy limits part, right? As far in the judgment itself, I think that Friedman and in Walker allows that because what they allow it to do is they allow it to be a judgment for the amount. And then but it also allows the insurer to, I guess, partially satisfy that judgment or satisfy the part that is in the underlying policy to do that as well. So I don't think the judgment itself says that prohibits the insurance company, GEICO in this case, from coming in and saying, okay, here's our policy. The interest meter stops on that policy now, right? Everything stops as to that policy. Now you got to go in the bad faith case and go for the bad faith part.
But
So I don't
before
think it stops
before the
at-
bad faith case happens, right? And they're only required to pay the amount under the policy, correct? Doesn't it put them at risk?
prior to it.
Yeah. Doesn't it put them at risk of violating the statute if they don't pay the entire amount of the verdict, not just the entire amount of the verdict limited to what their policy requires them to pay?
I don't believe so because I think that statute works hand in hand with also the bad faith statute and really bad faith law that comes out because I think the bad faith law is very clear that what the verdict amount is the amount of damages that a plaintiff seeks. And then when you take the amount of damages that a plaintiff can seek and put that into a judgment, but then also say that those damages are sought in another action, I think there is that. I can
Counsel,
see.
I'm going to ask your opponent this question, but
Yeah.
what harm visits you if if the judgment is just entered as to the amount that is required to be paid by the insurer at that point in time, as long as it's noted somewhere what the full amount of the verdict was?
Sure.
What harm visits you?
The harm that comes off the top of my head is that, if there was a judgment, and I understand, this is the amount of the verdict, but your judgment is entered for X amount. It's the policy limit. At that point, the Geico, there would be a situation where Geico would say, okay, well, the judgment is for whatever it is. They pay it, and then they would be moving for satisfaction of the judgment. That's the next step in that process. So once a defendant pays a judgment, the judgment is for X, and in the interest, then they move for a satisfaction judgment. Normally, the satisfaction judgment, once that's done, it is sort of an administrative rule, right? That is done just most of the times just with the state, and then that judgment is no more. And so there is a very real danger that the judgment that is entered by a court, which includes the verdict amount, no longer is there. And so if there is no judgment that includes the amount of the verdict, which would then translate to be the amount of damages for the bad faith case, then a defendant in a bad faith case say, well, there is no judgment against us. That's sort of the next step of the process. And I think that's why Fridman and Walker do it like that. They say that there is that push and pull within because bad faith is a very unique thing where you do get, you sort of front load the damages, but then after you get the damages amount, well, then you go for the liability part, which is the bad faith case.
But the damages amount is based upon the liability of the judgment debtor that we're now going to transfer. So they're stepping in the
That's
shoes
true.
of the judgment debtor, and we know how much the judgment debtor owes.
Oh, that's correct. And I think that's part of the reason why, and again, I might be reading it, but I think that's why they do that in a situation where if you have a judgment debtor, if you have an individual defendant, that's one thing. But if you have a company, then you're talking about the company having a damages amount. This is a UM case against them. The jury has determined that that's the damages for this case. For Geico to be liable for those damages, we as the plaintiff now have to go in a bad faith case and prove their liability, prove that they, violated the bad faith and good faith and all those types of things. But the jury has already determined what those damages are.
Right.
So there has to be, and Fridman and sort of the bad faith law all say that that is the way that juries know what the damages are. So that translates from what happens in that trial.
But wouldn't the
translates to
jury
bad
know what
faith
the
case.
damages are just upon the entering of the judgment against the driver, the tortious driver?
Not if the judgment's no longer there. If a judgment is entered,
But why wouldn't that be evidence in the bad faith case of the amount that was against the judgment debtor for which now you're suing the UM carrier to pay?
yeah, I mean, I think
I mean, I don't understand the evidentiary problem you're suggesting.
sure. And it is something of a looking ahead, right? Because I mean, they're really, when you get to bad faith, you don't really know what the instructions are going to be, right? Because I mean, the jury, I guess the judge can instruct the jury, hey, this is what the damages are, that you're not to do the damages, or the parties can just agree that that's what the damages are. But that's not, and maybe I'm looking at it more from what I've seen. What I have seen is that doesn't happen. When we get into bad faith cases, the insurance company wants to now come in and say, well, we should be able to basically have this jury determine damages. Even though it's against what it is, that's what's happening. And so when we don't have a judgment that does that,
That doesn't make sense.
I know it doesn't, but that's what's happened in a lot. Many bad faith cases that I've been involved in, they're because of the back and forth between it, the carriers typically want the judge to allow them to bring in all of the factors that were in the first trial under the guise of, well, you can't determine whether we were in bad faith.
Well, that's a liability question.
Correct, but it
But
also.
we're not into liability. We're into what amount of damage
Sure.
you can get if we have a judgment against the insured, right?
Right.
Or against the
Right.
court fees or in a UM case, that evidentiary, that's evidence in
Right.
bad faith case of what the ultimate, if they're liable, the insurance company is going to have to pay.
Right.
Because they are stepping in the shoes of the judgment debtor.
They are, but they are the judgment debtor, right? I mean, so yeah, they certainly are. I think that there are two different ways you can do it. I do think that you can, and I've seen it before, you craft a judgment that basically says the jury verdict is X amount. That is going to be the bad faith damages. I mean, I've actually seen
Is
that.
there
within
any
there.
damage besides the one that you've suggested
Yeah.
that occurs to you and your client in their general position, if that is the way it's done going forward?
Interest. Interest is a big part because when you look at what Florida law says, normally Florida law says that interest begins when the judgment is entered, right? And so when you have a judgment entered, well, as we did in this case, interest starts accruing on
So
it.
why are you entitled to the interest before liability is imposed against the UM carrier?
We're not entitled to the interest on the excess. We're not saying that. We're not saying that we're entitled on the excess. The only thing I'm saying right now is we're entitled to the without the bad faith case going on. That we have, if they wanted to give a check for the policy limits and the interest that's according to that, then that part, part of it is satisfied. However, the excess is not satisfied. That goes to the next trial, but there does have to be a mechanism for the interest to run on that. And interest, if you don't do a judgment that has interest running, you can't later on do it. There's cases that talk about where someone asks for a motion to enter a judgment and some time goes by and the hearing happens. Well, judges aren't able to kind of non-proton back to when the motion was. It runs from the judgment. And so that's so interest is a part of the damages that are in bad faith. And that's what has to be protected by, because otherwise there is nothing that talks about interest. And in a case like this, interest could be very substantial.
Thank you,
So,
counsel.
oh, thank you. No more questions? I apologize. I hope I've answered everything. Thanks so much. I think the court should affirm.
Recognized, and just would ask that you please counter whatever argument you have. Don't save time for that. Thank you.
Okay, absolutely. Before I jump to the form of the judgment, I'm going to take one more stab at the Binger issue, because I think it's a real one. And I asked this court just to look at the Binger case law. There is not a single case in Florida that I found or that anyone has, my opponent hasn't pointed out. I don't think there is a case where a party has disclosed an expert the substance of their testimony months before trial and made them aware of the opinions, where the court has allowed a court to strike the expert. So I'd ask the court to recognize that if you affirm what the court did here, I think it would be unique, and I think it would be contrary to what the case law makes clear in Binger. And again, I think it all comes down to, is there surprise in fact? And that cannot validly be claimed here. Okay, let's shift gears unless anybody has any questions from me. With respect to the form of the judgment, I think Vincent and then Hudnall out of the fifth, Vincent's in the second, they get the analysis right. They recognize that the fourth district in Walker was dealing with a different issue, right? It was dicta what they said. I think they said that they think the fourth was wrong, and I think they're right. I think the easiest way to why the fourth was wrong in saying that the preferable approach was to enter the judgment for the amount of the verdict is because Fridman didn't do that. If you look at what Fridman did is say you enter the judgment for the amount of the policy limits, which is what the law has always been in Florida. And then you can reference the amount of the excess judgment as the measure of damages that can be used if ultimately bad faith is if an insurer is found liable for bad faith, then that can be used as the amount of the measure of damages. But that is different than entering a judgment for the amount of the verdict. And that's what was done here.
Counsel, what harm visits you by counsel's proposal?
Well, the way the judgment was written here, interest is a big part of what is the harm. Interest under this judgment starting to run.
When do you think they would be entitled to interest?
When? When the bad faith is proven, I think it is an element of their damages. And you can plead that. And so I'm not sure what cases Mr. Lee's talking about, but I think you could potentially get prejudgment interest as an element of your damage in the bad faith case. This judgment, the way it's written, interest is accruing on the whole, the amount of the net verdict, because that's what the judgment was entered for. So, I think clearly Fridman explains it very clearly, and so does Hudnall. And, I think there's no basis. That's always been the law in Florida. The law is very clear that you cannot enter a judgment in the amount of the policy limits without a judicial finding of bad faith. So, we'd ask the court to, in the event that you're not going to order a new trial here, which again, I think the case law on the Binger issue is very clear. To let, the court was frustrated with both parties, but to translate that into, therefore, on the eve of trial, we're going to strike Geico's experts, we submit is unfair and contrary to what the law is under Binger. So unless the court has anything else for me, I'll rely on my briefs. Thank you.
Okay, thanks to each of you. What is adjourned?